Hello and welcome. My name is Annie Yang. I'm a 1L. I'm honored to introduce the 18th BCLT Annual Privacy Lecture. Today's lecture focuses on the topic of blanket opt-outs. Our speaker and accommodators will explore how the law treats blanket opt-outs across privacy, arbitration, and AI training contexts. It will look at when blanket opt-outs work, when they fail elsewhere, and where legal reforms or private sector solutions might offer a path forward. I am one of the VPs of Programming of Privacy Law at Berkeley, or PriveLab. PriveLab is a student-run organization at Berkeley Law that brings together students' interest in data security and privacy law and to introduce them to the substance of their future practice. Before we begin today's program, on behalf of PriveLab, I would like to thank Berkeley Law's own Professor Paul Schwartz for coordinating our speakers and putting together today's great program, and the amazing Berkeley Center for Law and Technology event staff. In particular, I want to recognize Richard Fisk, Amber DeGatto, and Justin Zhu for all of their hard work in making this event happen. And this year, Professor Lior Jacob Strahilevitz will give the BCLT annual privacy lecture. Professor is the Senior Austin Professor of Law at University of Chicago Law School, a role in which he has twice won the Graduating Student Award for teaching excellence. His teaching and research focuses on property and land use, privacy, law and technology, and consumer contracts. Professor Strahilevitz previously served as Deputy Dean of Chicago Law School, and in 2015 was elected to the American Law Institute. Before we begin, we would like to take a moment to honor Professor Strahilevitz in recognition of his contribution to the field of privacy and technology law. I'm honored to present on behalf of the UC Berkeley Center for Law and Technology the 2025 BCLT Privacy Award for Excellence in Teaching and Advancement of Research to Professor.
Thank you so much.
You can open it. So there was a slight mishap with the actual award. So in the meantime, we're going to present him with a UC Berkeley sweatshirt. So which is especially appropriate since Professor was an undergrad here. So we will mail him the award when it does arrive. Yeah. And in the meantime, we can read the inscription on the word. Is anyone who's in charge of the slides?
Oh, I think there's a clicker.
Oh,
Oh, yeah.
Yeah.
Oh. I think we just started.
Yeah, it might not. I think that's all we've got.
Okay, I will read. 2025 BCLT Privacy Award presented to Lior Jacob Strahilevitz for excellence in teaching and advancement of research in the field of privacy and technology law. Please join me in congratulating Professor Strahilevitz.
Well, thank you so much for that super generous introduction, and I'm glad you got in, sort of the accomplishment that I'm proudest of, which is having graduated from UC Berkeley in 1996. And for those of you who are students or alumni, this is, as far as I'm concerned, the greatest university in the world in terms of its ambitions, in terms of the kind of impact it's had on global society, and in terms of the upward mobility that it creates. I've been affiliated with some other fantastic institutes of higher education, and their ambitions aren't nearly as great as Berkeley's are, and I'm just extraordinarily proud to be a Golden Bear, and it's so fun to have any opportunity to come back here, but especially on this particular day, and thank you so much for inviting me. I'm going to speak about blanket opt-outs, which is mostly a talk about privacy, though at the end you'll see that there are ambitions to speak more systematically about topics that will reach other aspects of the law. And like all good scholarly projects, or maybe many good scholarly projects, this one was born of frustration. It's born of the frustration that would arise whenever I would get a little ping on my phone. Oh wow, maybe it's my spouse, maybe it's my child who's off in college, maybe it's a dear friend who I'm trying to connect. No, it's a political campaign asking once again for money on behalf of a campaign that I've never heard of, an organization that I didn't know existed, or someone who's challenging an incumbent in the 4th District of Michigan. And the phone kept pinging over and over and over again, and I kept putting it down without doing anything with the text other than being frustrated that I'd been fooled again. But I got more frustrated still when I read a piece by Adam Bonica, a distinguished political scientist, who let me know a little bit of the context for these notifications I kept getting on my cell phone, which was that at least on the Democratic side of the aisle, and at least if we're talking not about campaigns for particular candidates, but for the various public PACs, political action committees, and sort of NGOs that are trying to raise money for left of center candidates generally, it's basically one firm that's sending all of these text messages under dozens of different names. And notwithstanding that, you've basically got one organization, it's called the Mothership, and you basically got one organization with tons and tons of different affiliates, but it's all run by the same people. And by the way, most of the money doesn't go to Democratic Party candidates. By Adam Bonica's count, maybe 1% to 2% of the revenue raised eventually makes it into the coffers of candidates who are running for something. It's basically a self-perpetuating scam where the vast majority of the money gets raised, gets spent on sending yet more text messages and paying high-priced consultants. And this made me especially angry because, after all, it's the same entity that keeps sending me these things, but if I text back stop, which you're allowed to do under federal law, and entities are required to honor those requests that you stop texting them, well, that maybe works for one of the 28 different affiliates of Mothership, but it's not going to work for the other 27. And yet there's really no one entity that you can go to and say, hey, Mothership, just stop sending me texts of all kinds. I do like to donate. Sometimes I get invested in politics, but I'm never going to donate in response to all these spammy text messages. And so it felt a little bit like a game of whack-a-mole, where I'd keep texting stop, and I'd keep getting this, yep, we will remove you, and then 50 more text messages follow from slightly different entities. I will say whack-a-mole is actually fun, and this was not a particularly enjoyable exercise. And so that got me thinking, and maybe got some of you thinking, because you probably also reached for your phone only to put it back in disappointment. Got me thinking about the general phenomenon where in some instances we do allow individuals, consumers typically, to communicate to one entity that they'd prefer not to have their personal information used, or they prefer not to be contacted. And in various contexts, the law does allow those one-time opt-outs to be effective. But then it got me thinking about other really important contexts, privacy contexts, like the spam text messages, where we don't have anything like that. And I started wondering, well, why is that? Why do we have the do not call registry, but nothing like a do not spam registry? And my two great loves within the law are privacy law and property law. Those are the two courses I've been teaching since my rookie year as a professor. And I thought, well, at least with respect to aspects of this problem, that's a problem that property law solved hundreds of years ago. Okay, so If you put up a no soliciting sign on your door and someone violates the terms, they show up to try and sell you insurance or sign you up to contribute money to a charitable cause, or they're Girl Scouts selling cookies even, and they ignore a no soliciting sign, they have trespassed. The law is quite clear. The US Supreme Court's even weighed in on that issue. And while sometimes people put up no soliciting signs that are extremely detailed, I don't want political candidates knocking on my door. I don't want salespeople knocking on my door. I don't want to buy Girl Scout cookies. I don't want to buy encyclopedia. I don't want to buy this. I don't want to buy that. You'll sometimes see those signs. As far as property law is concerned, all you have to do is post no soliciting. And any of those individuals, whether they're raising money for commercial or charitable causes, they're violating your property rights and they're trespassing as soon as they knock on the door, as soon as they ring the doorbell. And the law doesn't require you, as far as property law is concerned, to identify all of the different categories of solicitors who you don't want to darken your doorstep, right? Imagine if property law said, well, if you don't want solicitors, that's fine. You can post a sign that says, no insurance salesmen, no home painters, no window cleaners, no lawnmowers, no this, no that, and then to go through every category of person who might have an incentive to ring your doorbell and try and solicit your business. I thought to myself, that would be insane. That would be a crazy regime if you had to post a sign that just went on for pages about all the people who could not knock on your door. And then I thought, but that basically is the rule for text messages, right? And that is the rule for these other areas of law where you literally have to tell each individual sender, hey, please stop trying to communicate with me, or please stop tracking my information, okay? So that's kind of the origin of this process. Annoyance and a thought that, at least with respect to some aspects of this problem, it's a problem that property law has solved, and why hasn't it been solved uniformly in privacy law? So I started spending time thinking about the literature, and there's a really great academic literature that's talking about it's talking about opt-outs and even blanket opt-outs in particular contexts. Chris Hufnagel's in the audience. He's written, I think, probably the best paper on the topic with Dan Solov. But what I noticed about the literature is that each of these papers have only thought about these kinds of blanket opt-outs in privacy with a focus on maybe one or two different kinds of domains in which the blanket opt-out could be applicable. So there's some really great papers on the do not call registry. There's a really lovely paper on the proposed do not spam registry, which went nowhere. There's some interesting papers on do not track for internet behavior and third-party tracking. But all these really nice contributions to the literature are, for the most part, piecemeal. At most, they might grapple with this blanket opt-outs problem in two or usually two, usually one. I think there's Chris and Dan's paper maybe thinks about three different contexts in which these blanket opt-outs occur. And that got me thinking, hey, there might be real value here to draw together all the instances in which privacy law facilitates these blanket opt-outs, where you can communicate one time with one entity in a way where your preferences will get communicated for all times to all entities. To think more broadly about where we see them, why we see them, and maybe more interestingly, where we don't see them, but where they might nonetheless belong. So, in my talk today, I basically am going to start out with two hypotheses that were with me one was with me at the start of the project, and the other is sort of evolved as I've looked at additional cases and tried to think coherently and systematically about what brings the different blanket opt-outs that we see in privacy law together. The starting out point is that in many contexts, as with these spam text messages, if you don't have a blanket opt-out right, you may as well not have a right at all. Okay? That in other words, the procedural mechanism of facilitating these blanket opt-outs is substantively decisive in whether people have a privacy right or a right to be left alone, and I'll try and convince you of that idea over the course of my talk if you're not immediately convinced. And the second, and this is really, I needed to do the work in order to reach this conclusion. I basically arrived at four ideas about what seems especially important in driving the success of these blanket opt-outs. What are the factors that keep showing up over and over again? Well, I think probably the largest factor is blanket opt-outs succeed where they facilitate the lowering of transaction costs and the lowering of administrative costs in order for individuals to have their preferences respected. But sometimes there's transaction costs that get in the way of successful implementation. That's point one. Point two is about contextual integrity. And this, of course, a super important, influential idea from the privacy theorist Helen Nissenbaum that talks about ways in which we might be comfortable sharing information with a best friend, but not with an acquaintance, or comfortable sharing information with a medical provider, but not with our spouse. And that's a really important foundational insight. But my thought is, as I'm thinking about these blanket opt-outs, sometimes we get carried away with contextual integrity, and sometimes people's preferences are really homogeneous across contexts. And when we find ourselves in those situations, then blanket opt-outs are going to be much more appealing. Third, we need to think seriously about comparative institutional competence. And as you'll see from this example, a lot of the successful implementations of blanket opt-outs come not from the public sector, but from the private sector. And then the final insight, I think the most recent idea that's showing up in the most recent drafts of the paper is an idea that blanket opt-outs are going to work especially well when terms are not priced. In other words, where the consumer can freely opt out, and where the consumer can opt out but is going to pay a financial penalty for doing so, then blanket opt-outs aren't going to work nearly as well. Okay. So I think there may be a generational divide in terms of people in this room who remember the rollout of the federal Do Not Call registry and those who don't. So this part of the talk is more for the benefit of students who maybe were very young when the Do Not Call registry was implemented. But many regard it as one of the most successful government programs of all time. You know, not as consequential as Social Security or Medicare or maybe the GI Bill, but extraordinarily popular, such that if you asked Americans at the time Do Not Call was introduced, do you like this program, do you not like this program? It hit, I think, an 83% approval rating, so just extraordinary for a government program. What did Do Not Call do? It addressed a pervasive problem, which was, just like I keep getting interrupted by these unwanted text message notifications, people were getting interrupted. Remember, this is before caller ID is widely available. People keep getting calls on their phone. They're excited to pick it up. Maybe it's my aunt who I haven't talked to in 6 months. No, it's timeshares. It's a timeshare salesman. How quickly can I get rid of this person, et cetera. And so consumers were really upset that their dinners kept getting interrupted by these telemarketers. And telemarketers back in the day was an enormous business. Okay, so if we think back to this era, before the Do Not Call registry, there were 4 million Americans employed as telemarketers or in the telemarketing industry. Just this is a huge number. 4 million Americans, a huge business, accounted for, in 2001, $275 billion in annual sales. Those are nominal dollars. So lots of people employed, but also lots of people annoyed, complaining to the FTC, complaining to their members of Congress about the annoyance of getting these calls, which turn out to be salesmen that they don't want to hear from. So what the FTC did at Congress's direction is it created a registry, and it said people can opt in to this Do Not Call registry. And telemarketing industry, before you place a call, before you allow a number to go into your automatic number dialer, you're going to have to check that number against this registry of people who opted out of receiving these calls. And if you find a number on that registry, you cannot dial that number. So that's basically how the Do Not Call registry worked. Create a master list and then make it a crime for entities to call numbers that are on the list. And the uptake on this program was really extraordinary. So Ian Ayres, the great contract scholar, refers to the iron law of default inertia, which is basically people are, for the most part, lazy, and so if you give them a default option, they're going to stick with it. They've got a lot of different priorities. Defaults are quite sticky. And this was a process where you had to actually figure out how to get listed on the Do Not Call registry. You had to provide your contact information, provide your name, and somehow, despite the fact that this was work, 57 million Americans in the first 6 months alone placed their residential phone numbers on the Do Not Call registry. Just, again, extraordinary uptake. And today, there's 253 million active registrants on the Do Not Call registry, which is a little surprising because there's only 69 million residential landlines. And so part of the project is trying to figure out what's going on there, because after all, most Americans now have cell phones, not landlines. And it's already unlawful to telemarket to a cell phone unless there's an established business relationship or something like that. But the FTC will let you list your cell phone on the Do Not Call registry. So my sense is that's a lot of number. Plus, there's probably a lot of old landlines that got discontinued in favor of cell phones, and those numbers remain on the registry. But the other thing that it did, in addition to generating 253 million active registrations, it basically killed off the telemarketing industry. So that telemarketing industry that was employing 4 million people is an absolute shell of its former self today. Now, I think the Do Not Call registry worked quite well. It's not perfect, though. The FTC lodges about 2 million complaints per year about the Do Not Call registry, and that's mostly about robocalling, and much of that robocalling, we think, is generated from callers overseas who are placing calls using technologies like VoIP. But interestingly, it's a little bit hard to see in a bright room like this one, but interestingly, in the last few years, we've also seen some private alternatives to the Do Not Call registry emerge, and Apple has really been the leader here. So in the top right-hand corner, there's a screenshot of Apple's block unknown callers. You can be heavy-handed about it and prevent anyone who's not in your contacts list from calling you. Or Apple, as of a few months ago, introduced kind of an intermediate option. The intermediate option provides anyone who's trying to call your cell phone, your Apple iPhone, with a prompt if you're not in their contacts, and says, can you please explain why you're trying to call Paul Schwartz? And if it's, this is Leo, Dad, I lost my phone and I'm borrowing a stranger's iPhone to call you, Paul's gonna want that call to go straight through. And if it's someone trying to sell him a timeshare in Acapulco, he's going to say, yeah, I think I'll let that go through to voicemail. So there's interesting technological innovation that we're seeing, though it does contain a pretty big false positives problem, which is some of those calls that are wanted might be missed. Some of those calls that are unwanted might sneak through. And I think one of the interesting things for Apple going forward is what's going to happen when people start lying about their reason for calling in order to get people to pick up. The technology is so new and not widely adopted so that we haven't really seen a lot of that, but surely that's going to happen. And one hypothesis that I articulate in the paper is, we've had the Do Not Call registry since 2004. If the FTC had never implemented it, I think you can be reasonably sure that Apple and probably Google, Verizon, T-Mobile would have implemented something like the Do Not Call registry at the device level or the customer level rather than going through the government. I'll talk about a second success story. There's more kind of successes and failures in the paper, but I don't want to run through all of them. But I think another sort of striking example that's as successful as Do Not Call in its own terms, but also implemented by the private sector, is another Apple innovation, which is known as ATT. Okay, so ATT was a kind of software suite rolled out as part of iOS 14.5 that allowed iPhone users for the first time to opt out of third-party tracking. So maybe you don't want to let the NBA app see your activity on Google Maps or vice versa. ATT all of a sudden allowed you to do that and say, I just want the NBA to see my tracking data from the NBA app. And interestingly, Apple created a couple of different ways in which individuals could opt out. There's an app level opt-out. I don't want to let the NBA track me across third parties or share my information with third parties. But then critically, Apple also built in a device level opt-out that says, I don't want to even be asked by Google Maps, the NBA, about these third-party sharing permissions. I just want no tracking. I want to see the prompts go away. I want the tracking to go away. In other words, this device-level opt-out basically says no to every request for tracking permission without the consumer even having to see that request or do anything. And the best study on how well this permeates suggests that in the United States, about 42% of iPhone users have opted out of third-party tracking at the device level. And in 18 countries outside the US, mostly Asia, Europe, Latin America, the number is even higher. So about 46% of people have exercised these blanket opt-outs. And these Apple choices have had really significant effects on the behavioral advertising industry. Apple iPhone users who've exercised either the blanket opt-out or the narrow opt-out are simply seeing a lot fewer personalized ads, and they're having way less of their personal information shared across different apps, companies, and platforms as a result. So I think of the device level opt-out as one of the most successful blanket opt-outs that's been implemented to date. But sometimes these things fail. Okay? So the Do Not Call registry, again, I showed you, is hugely successful. And so Congress thought, hey, people actually like something that Congress has done. This is great. People don't like spam email. Let's do not call, but for spam email. And in the Canned Spam Act, they authorized the Federal Trade Commission to create a do not spam or a do not email registry that was going to do for spam emails what do not call did for telemarketing calls. And the FTC spent the better part of a year studying this, and they came back to Congress and said, hey, Congress, you've given us all this room to create a popular registry, but we don't think we should. And the reason the FTC, the report's available online, it's an interesting read from 2004, the reason they said that is the problem of spam is different than the problem of telemarketing, or at least it was in 2003, 2004. Most spam was originating overseas, and the FTC thought that they would have a devilishly hard time either building a framework to authenticate commercial emails or successfully intervening in order to prevent these third parties that were located overseas from going to the do not email list, harvesting all the email addresses that had been listed, and then spamming all those people with unwelcome commercial emails. And indeed, there's even, in some ways, this would be a much more tempting target than the do not call list would be for unsavory telemarketers, because after all, what telemarketers are doing are just randomly dialing digits. And if you randomly dial digits, you're likely to get a number. But that's not going to be true with email addresses, or not nearly to the same degree with email addresses. And so creating this super comprehensive list of people who really don't want to get commercial emails and sending them commercial emails, the FTC was really worried that creating such a registry would backfire, and it would make the commission look bad. The other thing the FTC report says is we don't currently have a good enough email authentication standard to make this technically doable, but when we do, this is something Congress should reconsider. 2004 was a long time ago. We now have several authentication standards that are much more workable than anything we had in that era, but Congress has never revisited the issue of should we create a do not email registry. In part, you can think about the reasons why. In part, because any email provider, whether it's Gmail or Outlook, has already developed their own internal spam filter to try to substitute for what a do not email list would have done, though of course those filters are going to have false positives and false negatives. There's the really important email that you don't get because it was blocked by your spam filter. There's the spam that makes it through because you've got this sort of cat and mouse game where the spam senders are always trying to figure out how they can get a commercial email through the state-of-the-art filters. I'll tell one other story of a failure, which is the do not track regime. So do not track was an effort to try to, again, limit tracking of people's information across third parties on the internet, to clamp down on the flow of big data into behavioral advertising. And do not track was an industry effort to self-police that was strongly encouraged by the Obama administration, with the Obama administration saying to the behavioral advertising industry, you all need to shape up. Privacy isn't being respected on the internet. You need to police yourselves. If you do, we'll back off. If you don't, we're going to come in with regulation. Years and years were spent developing both protocols and the public policy case for implementing do not track. Unfortunately, it wound up going nowhere. The big sticking point in the negotiations was the industry agreed to abide by do not track signals that were sent by individuals' browsers if those individuals had affirmatively switched the default from track to do not track. But what the industry refused to do was honor do not track requests from browsers where do not track was enabled by default. And that was a really big sticking point because, one, defaults are sticky. Most people, do not call aside, probably weren't going to opt into do not track. And secondly, and critically, Microsoft Internet Explorer had turned on do not track by default. As best we can tell, Microsoft had done user studies, and they asked their users, hey, do you want do not track to be on? And all the users said, yes, we'd really love that. So Microsoft said, great, we'll make it the default. And the ad industry said, well, lots of people use Internet Explorer, so lots of people are going to be opted out of tracking. That doesn't count. And it even isn't going to count if someone picks a browser like Firefox or DuckDuckGo's browser, which is marketing itself as the privacy protective browser that's going to have this stuff on by default. The ad industry said, we won't honor it. And then the momentum for legislation by the time this all got sorted out failed. The sort of modern version of that is something called ad choices, which is a joke. The uptake on ad choices is 0.25% of users invoke their rights not to be tracked by ad choices. And the behavioral advertising industry basically has no incentive for people to find out that they have internet privacy options under ad choices. Okay, and then I'll just talk about a few cases that are interesting ones that are kind of in between. They're not successes, they're not failures, but they do show that this idea of blanket opt-out's actually rather pervasive. So these are a little bit of obscure and maybe even a little bit fun. Many of us have gotten pre-approved credit cards in the mail, where they don't send you the card, but they tell you, hey, congratulations, you're pre-approved for a Visa with this rate. And the only way that's allowed to happen under the Fair Credit Reporting Act is because of a provision in the Fair Credit Reporting Act called, that deals with what's called pre-screened offers of credit or insurance. So that's, for those of you playing along at home, 15 U.S.C. 1681b subsection C, which allows the credit reporting agencies to sell lists of people who have who meet a particular credit score cutoff to these credit card issuers or to these insurers. But, Congress said, you can only start sending out these pre-screened offers if you also create a one-stop shop for individuals to go to and communicate with one step to all the different credit card issuers, all the different insurers, that they don't want to receive these pre-screened offers in the mail. And so today, you can go to optoutprescreen.com and stop getting these various solicitations. I've done that. It actually does reduce the amount of junk mail you'll get. It's been a while since the Federal Reserve has studied this, but when they studied optoutprescreen.com, the respondents, sort of a Gallup poll basically, 80% said, yeah, this is a really good idea. But only about 5 to 6% of Americans at the time had ever exercised their rights to engage in the opt-out pre-screen, the blanket opt-out. So people really like the idea, but almost no one is sufficiently motivated to go to this website. It takes about 2 minutes to opt out. But the other issue is people just don't know about it. There's very low awareness of it. And so it just doesn't, there's just not been that much uptake. A more obscure version of this, with some kind of interesting history, is when we go back to 1967. So in 1967, it was a significant political issue that people were getting lots of unwanted, sexy mailings, right? So this is before the internet. If you're trying to market pornography, how do you do it? Well, there's no email, there's no internet. You're gonna send racy materials to people's homes, and turns out some people are gonna be great, sign me up, and some people are gonna be offended by what they received. So in 1967, Congress passes a law that says if you're getting too much email from this particular purveyor of adult material, you can file something with the US Post Office, you can go fill out a form and block that sender from mailing you stuff. Okay, seems like a pretty good solution, but it's not a blanket opt-out. What happens? Well, we get the mothership strategies problem again. People are getting these these snail mail solicitations from 20, 30, 40 different entities, and they can't keep up with filing these forms. And this actually became a big political issue that Richard Nixon ran on and campaigned on. He said, I want to prevent all these mailings from clogging up your mailbox with ads that you don't want your children to see. And so in 1970, Congress passed a new law where they actually created a blanket opt-out for sexually explicit mailings, and it's called Form 1500. And if you go to your postal service office, one in Berkeley, you should ask them, do you have a copy of Form 1500? And they'll probably say, like, you're the first person in 4 years to ask about this form, that's my guess. But any empirical, anecdotal information is quite welcome. And that form still allows you to opt out, not just of one party's sexually explicit mailings, but any party's sexually explicit mailings. Uptake on that, we actually don't know. The Postal Service has never, to the best of my knowledge, published any statistics on how many people have filled out this form. We do know from the 1970 legislative history that the 1967 law, in the first 2 or 3 years, sparked about 460,000 people to fill out this form and say, please stop sending me stuff. But we don't know what the utilization was on the blanket opt-out. Having said that, it seems like the internet basically made any marketing of sexually explicit materials go from snail mail to online marketings. And so there's less cause for Form 1500. But what's interesting, I think, and maybe what we can take contemporary lessons from, is Congress passes a law, but it lacks a blanket opt-out, and everyone complains and says this law is not doing anything, so Congress creates the blanket opt-out in 1970. Cookie consent is another issue where people are just repeatedly going to see prompts as they navigate the internet. Do I want to enable necessary cookies? Okay, I don't really have a choice there. What about personalization cookies? What about statistics tracking cookies? What about all these different things where I'm not just going to have to make those kinds of decisions when I go to a website for the first time once, but I'll have to keep making the same decisions over and over and over again. Analytics cookies. My instinct is people tend not to have granular preferences such that they're really excited about enabling analytics cookies on one website, but not on another. Rather, what's causing people to click is they're in a hurry, there's various dark patterns, manipulative online interfaces that are getting people to agree to cookies that they're not wild about, and they just want to see the content. They just want to get through this cookie consent interface as quickly as possible. Now Brave, another sort of pro-privacy software entrepreneur, has said, people really don't like these cookie consent interfaces. It's constantly slowing down the internet, so we're just going to build into our Brave desktop and mobile browsers a little feature that will automatically say no to any cookie consent request where it really is optional. And so consumers using Brave won't even see these cookie consent pop-ups. And I have to say, I switched over about 4 months ago. It's great. It really saves time. And Brave's insight is people just don't have these granular preferences, and a lot of people just want to constantly say no. And if you make that easy for people to do that, maybe they'll start using our browser. Now the problem is only about 1.5% of the world's internet users are using Brave. So even though it has this, to my mind, great advantage over Chrome and Safari, it's a startup, it's trying to gain market share. This is kind of its killer feature to try and do that. But a lot of people have never heard of Brave. or they're just so embedded in using Chrome and Safari that they're not interested in making the switch, even though it frankly just works better. Okay, and then I think maybe most critically for this audience, especially in California, there's some very important blanket opt-outs that the CPPA, which of course Jennifer has been deeply involved with, that the CPPA and the California legislature have been requiring. And I think the two most important of these are global privacy control and DROP. Let me talk a little bit about those, and some of this will be very familiar to some of you in the audience, and maybe for some of you, you're learning more about it for the first time. So global privacy control is basically an updated version of Do Not Track, where individuals are going into their browsers and they're selecting not to have their personal information shared or sold to third parties when they visit a website or when they use an app. And global privacy controls eliminates the need, which would otherwise arise under the CPA, for individuals to, at each website they go to, click on a hyperlink and then go to a web form where they say, please don't sell or share my personal information. Probably everyone in this room, if you were to go through your internet browser history, maybe you've been to 50 websites this month, maybe 80 websites this month, and nobody wants to send 50 or 80 different website opt-outs. And global privacy controls promises to prevent you from having to do that. It'll automate that. It'll automate that process for you. Now, in most states that have, like California, enacted state comprehensive consumer privacy laws, entities are not required to honor these signals sent by browsers that are implementing GPC. But in California, websites are required to honor these requests that come from browsers. But the main problem is that for most browsers, they either don't allow GPC signals at all, which is the case with Apple Safari, or they do allow them, as for example with Google Chrome, but individuals have to go find a Chrome plugin and install it in order to enable GPC. Again, there's some exceptions. DuckDuckGo and some other websites automatically enable GPC. But this is what's really important. Governor Newsom signed a law just about a month ago that going forward is going to require all websites that are subject to the CCPA doing business in California to create a built-in GPC option. And then once users have gone into their settings and enabled GPC requests, if it's not done by default, then separately, in California anyway, websites and apps are going to have an obligation to honor those GPC requests. In other words, this is a very big deal. Okay, very big deal, a very big win for internet privacy, and a blanket opt-out that's just frankly so much more practical than forcing individuals to go website by website in order to protect their privacy online. And the available research, especially the research coming out of Sebastian Zimek's lab, suggests that this blanket opt-out option, if consumers know about it, is going to be super popular, much more popular than more granular decision-making, where people maybe allow tracking by some third parties and not by others. Another private sector version of this is actually, hallelujah, addressing that spam text messaging, political text messaging problem that I identified right at the outset. So if you have an iPhone and you've updated your operating system to the most recent version of iOS 26 point something or other, you now have an option to screen unknown senders. It's not enabled by default. You have to affirmatively do it, and my paper walks you through how to do it. It'll take about 3 or 4 minutes. But what it allows you to do is have any email, any text messages that's coming from someone not in your contacts or someone who Siri thinks is important and probably not in your contacts but ought to get through nonetheless, to go to a separate text message folder, not your main text message folder. and to stop notifying you when you get such a text. So your phone will just stop buzzing. And if you want to make sure I didn't miss something, you can always, switch over to that folder and see what the unknown senders are sending you, and you'll probably find some relevant stuff there. And if you find, oh gosh, I actually want text messages from that person to come through, even though they weren't in my contact, all you have to do is just click Mark as Unknown, and going forward, they will always go to your main text messages folder, and you will automatically get a notification just like you would with any other text. There's some false positives with this process. It's an imperfect process. But here's what I think is especially interesting. Apple was under tremendous political pressure as soon as they announced that this new feature was going to be available in iOS, especially from the Republican Party. So the Republican Party and the Democratic Party, to be sure, raises a lot of money through these text messages, and they knew that people really don't like receiving these text messages. So they sort of put the word out that they were none too pleased with Apple, which, given the political environment in the United States in 2025, Apple needed to have some internal conversations about what to do about the fact that the party in power very, very upset about this new feature that was going to allow people to block unwanted text messages. So I think a couple things happened in response to that. In some of the early press coverage of iOS 26, it was suggested that Apple would turn this feature on by default because it was likely to be really popular for iPhone users, and it's not on by default. Might be that the political pressure influenced that, although I don't have any inside information. That's just speculation on my part. And the other thing is, this is a really important, wonderful, to my mind, Apple feature that you probably haven't heard about. Apple's not advertising about this at all. And again, the reason they're not advertising is they probably don't want to generate more political heat than they're already getting as a result of the change. And this is a big deal because there's more iPhone users in the US than there are Android users. Apple has a big, big share of the smartphone market. Okay, DROP Act, again in California, is the other really important and kind of exciting version of this. The Delete Act allows an individual in California to request the deletion of their personal information that's held by data brokers. And we can imagine a sort of no soliciting problem again. According to my student, Elijah Grease, the most recent count, there were 527 different data brokers doing business in California, and I don't think a single individual has the patience to contact them all individually. And the Delete Act and some of the regulations enacted pursuant to it say you don't have to. We're going to create the DROP. This is very, sort of hot off the presses regulatory development. DROP is going to be the one-stop shopping, the blanket opt-out that allows an individual who wants their personal information deleted by data brokers to go to one website, send a request, and that request will then go to all the different registered data brokers. And what data brokers doing business in California have to do is they have to consult the registry every 45 days and see, okay, what are the new requests that have come in, and then promptly implement all those requests. And so structurally, DROP is going to look very similar to the Do Not Call registry. There's going to be a single source that the regulated industry has to consult and respond to in real time. Okay, let's see. Did this? Oh, okay, great. Just a couple more slides, and then I'm so looking forward to hearing from our two distinguished commentators. So what can we learn from all of these different studies? Okay, I've given you a laundry list, given you a typology. I can't see how many. What's the number on that sign holder? 3. Thank you. Okay, I'll be done in 3. So at the outset, I kind of flagged these different lessons and these commonalities as we think about where we see successes and where we see failures. So kind of what do we learn from all of this? Well, blanket opt-outs are going to be popular and more likely to succeed where there's lots of participants in the marketplace and not so necessary where there's only a few. If you only have to communicate your preference to a couple of entities, then there's simply less upside from a blanket opt-outs. But we should also think about how costly is it to blacklist and whitelist. There's going to be false positives and false negatives where you do want certain text messages to come through from someone even if they're not in your contacts. And the more you're going to need to establish a blanket opt-out and then modify it for individuals, the less successful the blanket opt-out is going to be. There's also, I think, as some of these examples show, it's just really expensive to make consumers aware of their privacy rights and new privacy innovations. So we need to consider these costs as we're thinking about these blanket opt-outs. I've already kind of talked about the contextual integrity point, but what I will say is the paper summarizes a lot of data to suggest that people's online privacy preferences just aren't that granular. And therefore, in a lot of contexts, though by no means all, these blanket decisions might be the kinds of decisions that people want to make. We should think a lot about comparative institutional competence, where we've got a problem like spam, where the problem is international in its dimension. There's reason to think that the private sector is much more likely to be successful at implementing a blanket opt-out than the public sector will be. There's also tools that private sector entities are sometimes going to have that's going to be quite costly for government to obtain. So we want to be thinking about institutional competence. And in some instances, the decisions to opt into privacy might be costly for consumers. There might be a price tag associated with that. And where that is the case, as opposed to just kind of a free decision like you get with CCPA rights, where it's not a free decision, blanket opt-outs are going to be less appealing. So in kind of the last minute of my talk, I want to kind of look forward and say this has been a talk about privacy. I'm really interested in privacy, but we might be thinking about blanket opt-outs in contexts that have less to do with privacy as well. So a few cases that strike me as very much in line with some of the privacy examples where these blanket opt-outs have worked well are things like electronic delivery. We're constantly being inundated with requests to allow for electronic delivery instead of snail mail. And my strong prior, though I haven't yet studied it, is people tend to have pretty homogeneous preferences. There are snail mail people and there are electronic delivery people. And maybe there's certain people who only want a particular thing to come via snail mail. But for the most part, people are going to fall in one or the other camp, suggesting a blanket opt-out may be appropriate. I think a more provocative suggestion is that the same thing is true of class action participation. So a huge, huge problem from the efficacy of class actions is that the vast majority of people who are notified, hey, you're a member of a class, do you want to opt in? Do you want to opt out? What do you want to do? Do you want to make a claim? The data suggests that like 90% of people don't ever respond. So a lot of people who are entitled to proceeds from class action settlements never get anything, in part because they're getting these confusing emails or postcards in the mails. They don't know what to do with it. They put it on a shelf somewhere. It collects dust. They miss the deadline. Maybe people just have preferences to be a part of a class or to not be a part of a class. You can imagine, enforced at the federal level, a blanket right that allowed to accomplish that. What about consents to participate in medical research when we see a medical provider or a healthcare provider? Those of us near Berkeley, near the University of Chicago, are going to get those kinds of requests all the time. And again, my sense is, I don't really care about it's my dermatologist versus my cardiologist versus my gynecologist. I want to be a part of research or I don't want to be a part of research. Preferences, in other words, might not be granular, and so it might be that it makes sense to avoid these kind of repetitive asks and swap in a blanket opt-out. I think things like arbitration and AI training on copyrighted works, think of a journalist who's writing for a freelancer who's writing for a number of different outlets. These might be applications, though I do think both of them in the US context seem to fail at least one of the tests that I identified on the previous slide about when these things succeed. But certainly what we want is more empirical testing on things like how granular are people's preferences and what are the costs of blacklisting and whitelisting where we encounter a blanket opt-out. So last slide. If you want to take away a couple of ideas, take away these. First, over time, California's efforts notwithstanding, it seems like we're seeing fewer governmental efforts at the federal level to establish these blanket opt-outs, and much more efforts by the private sector, especially Apple, but not only Apple, to try to implement opt-outs. And my guess is that's sort of the wave of the future as well. So as we think about sort of the blanket opt-outs that are coming, some of them have to come from the government, but I think a lot of them will come from the marketplace. And then sort of the general point about privacy is one of the big debates. If you take Paul Schwartz's amazing privacy classes at Berkeley, you will learn that one of the big debates that's basically been settled is that notice and choice does not work. Notice and choice is the privacy regime where we give you a bunch of information, we disclose a bunch of information to you, and then we let you make choices that reflect your preferences, understanding that Paul and I may have different preferences and we should be able to do some tailoring. What I want to suggest is that maybe a big problem, not the only problem, but a big problem with notice and choice is that the reality of notice and choice is it's notice and notice and notice and notice and choice and choice and choice and choice. Because we don't have blanket opt-outs everywhere where we should have blanket opt-outs. And maybe if you just give individuals these one-stop shopping options and the opportunity to make a choice once and have that choice control a lot of their interactions with entities they do business with, maybe notice and choice actually doesn't break in those contexts. It's just because we assume that people's preferences are so granular, so context dependent, that we overwhelm them with disclosures and choices, and the result is they're not reading any of the disclosures and they're not effectively exercising any autonomy at all. So I'm going to stop talking now. I'm so excited to start listening, and thank you for being such a terrific audience.
Thank you, Professor Strahilevitz, for your insightful lecture. My name is Gabrielle Ledun, and I serve as one of the 1L representatives of PrivLab. And I'm pleased to introduce our distinguished commentator panelists who will further discuss these critical issues. First, it's my pleasure to introduce Professor Paul Schwartz, a leading expert in information privacy and law. His work focuses on how legal systems regulate technology and its impact on democracy. Professor Schwartz teaches classes on information privacy law and cybersecurity law here at Berkeley Law, and his influential work has been published in many top journals like the Harvard Law Review and the University of Pennsylvania Law Review. He is also the co-author of Information Privacy Law and Privacy Law Fundamentals. Among many other activities, he has testified before Congress, advised the European Union Commission, and consulted for various corporations on privacy issues. Next, I'm pleased to introduce Lindsey Tonsager, partner at Covington & Burling. She co-chairs Covington's Global Data Privacy and Cybersecurity practice. Lindsey helps national and multinational clients across a broad range of industries navigate federal and state data privacy and communications laws and conducts privacy and data security diligence in complex corporate transactions. At Covington, she focuses on designing risk-based global privacy programs for clients that can keep pace with the dynamic regulatory environment and efficiently leverage the client's existing privacy policies and practices. Finally, I'm pleased to introduce Professor Jennifer Urban, a clinical professor of law at Berkeley Law, where she is director of policy initiatives at the Samuelson Law, Technology, and Public Policy Clinic. In March 2021, Professor Urban was appointed by California Governor Gavin Newsom to be inaugural chair of the California Privacy Protection Agency Board. Before joining the Berkeley Law faculty, she founded and directed the USC Intellectual Property and Technology Law Clinic at the University of Southern California Gould School of Law. Her research focuses on intellectual property, privacy, and data protection, and security, and she regularly collaborates with technologists and academics in non-legal disciplines to develop empirically grounded understandings of how new technologies and existing regulatory structures impact civil liberties, innovation, and creative expression. Please join me in welcoming our commentators.
I'm going to, I think, more moderate than comment, and so let's turn it over to Lindsey first.
Great, thanks. So I was struck by the key question in the paper, which is why a legal instrument we all take for granted, a no solicitation sign that is effective against anyone who wants to knock on your front door, is unavailable in many online contexts. I think there's at least 4 reasons why it's reasonable and appropriate that people can exclude all trespassing on their personal property, but not universally prevent others from engaging in activities that may annoy them. Before I dive into that premise, please note I'm speaking only on my own behalf. I'm not speaking for any client or my law firm. My goal here is to really keep things interesting by providing perhaps a different perspective, since I'm guessing there's going to be overwhelming approval for blanket opt-outs on this panel, and possibly even in this room. So hopefully these 4 ideas will provide some context to maybe preemptively react to these reactions. So in summary, the 4 reasons I'll explore in my remarks are that the home is special. Second, that blanket opt-outs don't work and consumers don't understand them. Third, that blanket opt-outs can have the unintended consequence of actually undermining privacy and individual autonomy. And finally, that blanket opt-outs cannot be divorced from the highly normative and, dare I say, paternalistic judgments about what are good nudges versus what are bad nudges that should be disfavored. So first, the home is special. Using trespass law to prevent solicitation on a person's own doorstep is about the sanctity of the person's home, her castle, which holds a special place in US legal frameworks. In contrast, a consumer's ability to use trespass law to prevent solicitation, or any other practice for that matter, outside of the physical confines of their home falls apart. For example, a consumer can't make a billboard go dark as they drive down the highway. They can't prevent leaflets being left on their car windshield if they park on a public street. And they can't prevent people from asking them to sign a petition as they walk down the sidewalk. The no solicitation analogy is especially inapt when consumers access websites, apps, or other online services. In the no solicitors example, someone is stepping foot on your castle grounds. But when a consumer visits a website to, say, shop for a sweater, that consumer is stepping foot on the retailer's grounds, whether physical or digital. Why should the consumer be able to exclude that retailer from collecting data on the retailer's own premises, or allowing others that the retailer has invited onto their grounds to do so? Second, blanket opt-outs don't work and consumers don't understand them. You take the do not call list, which the paper characterizes as a real success story. And maybe it was when it was first enacted. But is it still today? Is it really? If that's the bar for success, that bar is perhaps incredibly low. As you mentioned, do not call complaints have consistently been one of the top consumer complaints with the FTC. That's through the Consumer Sentinel Network reports. I personally haven't had a landline since I left my house for college, but whenever I go visit my parents, the phone is ringing off the hook still with these robocalls. And as you recognize, that's mostly because ex-US fraudsters and scammers exploded as soon as the long-distance charges went away. And legitimate marketers who did honor the do not call list when it first came out and continue to honor the do not call list just found other ways to reach people with their ads, such as emails, text messages, and online advertising. So what's the response to these ads that have moved elsewhere? Give consumers a blanket opt-out for those ads too. What's that tell you about the actual goal of these opt-outs? It's not really privacy. It's people not liking ads and trying to legislate against annoyance. This is consistent with what I sometimes hear anecdotally from companies that get customer service complaints with respect to these opt-outs. Consumers think that opting out will or should stop all ads, and they get annoyed when they find out that the opt-outs don't actually prevent all advertising, only very specific types of ads. Another example of consumer confusion around the scope of blanket opt-outs is the global privacy control. As the folks in this room likely know, the global privacy control is an example of a blanket opt-out. Using their browser, the consumer can send a signal to all websites they visit that they don't want their personal data to be sold or shared for cross-context behavioral advertising. I was really interested in the Zimic article that you referenced, which the article suggests finds that consumers understand the scope of the GPC. So I took a closer look at that research in order to kind of pressure test if it actually supports that claim. Notably, the cited study found that 29% of respondents said they would send the global privacy control signal to most websites I visit. And another 6% of respondents reported that they would send this GPC signal, the global privacy control signal, to only a few selected websites I visit. That suggests that over a third of respondents apparently didn't understand that the global privacy control is a blanket opt-out. You don't get to choose to send it to most or all, you're sending it to all, or most or some, you're sending it to all. Moreover, the ZIMIC study that the article cites to asked respondents to answer the question, what do you expect to happen if you enable the global privacy control? When asked this question, respondents were shown a screenshot of a GPC toggle, a made-up GPC toggle, before they answered that question. And that screenshot stated, and I'm quoting here, enable GPC to opt out from data selling/sharing. Even with this, I'd say, inappropriate priming that certainly biased the survey results, most respondents still answered incorrectly. 81% said that websites respecting GPC would be prohibited from giving advertisers your data. That is not correct. GPC does not block all sharing of data with advertisers. It blocks only sharing for cross-context behavioral advertising specifically and data sales. Another 12% responded that GPC would prohibit data collection, would prohibit the display of ads, or my personal favorite, would be respected for every individual in the world. Also not correct. In a separate question asking respondents why they would enable GPC, only 35% responded limit data selling sharing. So it seems to me like it's a stretch that consumers actually understand what the GPC does, at least based on the ZIMIC study. Not only are blanket opt-outs ineffective, but third blanket opt-outs can have the unintended consequence of undermining privacy and individual autonomy. This privacy risk is apparent when considering the FT's recommendation not to support a do not email list. Unlike the do not call list, which consists primarily of publicly available phone numbers, the FTC expressed concern that publishing a list of private active email addresses could diminish consumer privacy by making that information more broadly available. Furthermore, online opt-out mechanisms tend to be at the browser or device level, but people use many browsers and devices, and many devices are shared by multiple people. What this means in practice is that if we really care about individual autonomy, everyone either needs to be logged in everywhere at all times, or they need to undergo identity verification to exercise their right, because we need to make sure that the blanket opt-out is actually applied to the person who wants to exercise that blanket opt-out right. Professor Strahilevitz rightly cautions that policymakers should be attentive to the cost of authenticating individuals' identities so that we are certain that the person making the autonomous choice to opt in or opt out is actually the person whose data is at issue. An example where this identity verification is required is the California Delete Request and Opt-out Platform, or DROP. Cal Privacy demoed the DROP system at the last board meeting. This is a type of blanket opt-out system. It allows consumers to submit a deletion request through a single portal maintained by the government that over 500, you got a more precise number than me, registered data brokers will need to check and honor. The first step to submitting a request is to verify that the person submitting a request is a California resident. Makes sense, the law only gives that right to Californians, which they do through the California Identity Gateway or the federal login.gov, which I believe, you can correct me if I'm wrong, uses government-issued IDs like a driver's license. Otherwise, if you don't require identity verification, blanket opt-outs will be applied to the wrong people. For example, the California Attorney General recently entered into a settlement with the Smart TV app resolving allegations under the CPPA. The smart television context is a great way to illustrate the issue of overkill or underkill. In my family, 3 different people are watching the television at any given moment, frequently simultaneously. A device-level blanket opt-out is not likely to reflect the preferences of each family member unless we all agree to the same choice. And that's a problem if what we're really trying to do is to facilitate individual autonomy and choice. Which brings me to the 4th reason, to resist the widespread proliferation of blanket opt-outs. They're a codification of highly normative and paternalistic judgments about what are good nudges that should be favored over bad nudges that should be disfavored. The paper asserts it's unreasonably burdensome for consumers to play opt-out whack-a-mole, but why? I want to participate in all loyalty programs. Automatically sign me up. Or every time I do something dangerous, like visit the trampoline park or jump out of a plane or whatever it is, I have to fill out a new waiver and release form in order to enter the premises. And I always leave a 25% tip when I'm at the restaurant, but I still have to add it every time that I pay the bill. It would really, as a consumer, I find this friction incredibly annoying, a waste of my time, and unreasonably burdensome. It would really promote my personal autonomy if I could just send a signal to all of these institutions and have my preferences to opt into the loyalty program or engage in the dangerous activity or always leave the tip, and that they'd ingest and honor that preference or choice. But these aren't the types of choices that are typically thought about when we think about blanket opt-outs. Rather, it's usually a handful of activities like using my personal information for AI training or cookie consents or arbitration clauses and class action waivers that happen to be on the more consumer-friendly, good nudges that are preferred by some in society, but disfavored generally by businesses, which I don't think is a coincidence. Now that might be fine. That's totally fine from a policy perspective to argue that we should promote good nudges. But the paper states it's not making claims about social welfare. And so my point is that these two things, when to make it easier for consumers to opt out at scale, and when they need to make granular decisions, can't really be separated from normative judgments about what we think is good or bad in society. As the paper points out, there are important trade-offs anytime a business has to honor a blanket nudge. But there are going to be policy disagreements about what good and bad nudges are, and we shouldn't try to hide the ball that that's what's happening here. And I think that's relevant for the first hypothesis you shared on the screen, that the absence of a procedural blanket opt-out right renders a substantive privacy protection meaningless. It's also possible that keeping opt-outs granular is one indirect way that we help balance those social welfare trade-offs. That a person needs to care so much that they're willing to go business by business to business to opt out, that it kind of counteracts the trade-offs in social welfare that these opt-outs entail. I'll end with an interesting twist. Collection and use of personal data, including for AI training and personalization, is actually what works best in responding to consumer preferences. This is notwithstanding the fact that the regulatory trend has been to make it harder to use personal data for training AI and for personalization. For example, while a do not email list never got off the ground, as you mentioned, what actually solved the spam email crisis was email providers using personal data to develop algorithms to identify spam and personalize the user's inbox based on predictions of what email that specific person wanted to see and what they likely would think is junk. So maybe the answer isn't more blanket opt-outs or even more choice, but more data processing as long as it promotes social welfare.
Thank you. Let's hear from Jennifer.
Wonderful. Thank you so much for having me. And thank you, Lindsey, for working hard to be provocative, I think. And I hope Lior appreciates that.
Very much so.
Yeah, I appreciate that. So as the introduction said, I'm Jennifer Urban, and I'm a professor here at the law school, and I'm also the chair of the board of the California Privacy Protection Agency. Everything I say is my own view, unless I designate it otherwise. The agency doesn't take a position unless the board, which holds the authority, votes to take that position. For example, we supported and sponsored the opt-out preference signal bill that Professor Strahilevitz talked about. So I can say that, but generally, this is my own view. I want to say a couple of broad things about the paper, Professor Strahilevitz. First, with my scholar hat on, this is a really wonderful paper. I appreciated the way that you marshaled a tremendous amount of evidence in service of a sort of broader general question. And the bottom-up approach, I think, was very revealing. And by that, I mean collecting all of the various sort of examples and case studies and working through them. And for those of you who haven't seen the full paper, I know it's in draft, and eventually you will feel comfortable posting it. You will see what I mean. As Lindsey alluded to with real property law, we have a lot of experience. We have hundreds of years of experience, and we have very good and settled ideas, which I'm going to try to complicate, about where the interests lie and where the fundamental rights lie, and then how we should go ahead and implement those rights. And in this area, there is at least the argumentation, and I mean this from lots of different interests, that it is all much less settled, and it is harder to discern what the appropriate, frankly, substantive approach should be. And so this kind of bottom-up approach, I think, is key, and there's kind of no other way to go about it to get a full picture. My reaction as a regulator was that a lot of this is right and that it is incomplete. And I go to your hypothesis, which I think Lindsey also quoted, that in many cases the absence of a procedural blanket opt-out right renders a substantive privacy protection meaningless. Interestingly to me, actually, I thought I was having a scholar reaction, and then I identified it as a regulator reaction. It's the substantive part that my concerns ended up largely being about. And why is that surprising? Because the regulator's job, of course, is to implement the substance, first of all. And secondly, in California, as Professor Strahilevitz gave you some examples of, there is a great deal of thought given to the procedural protections around substantive rights and the ability for consumers to vindicate their underlying substantive rights in practical ways, while balancing that with businesses' need to also implement those rights. I'm all for blanket opt-outs in appropriate contexts, and it's exactly right that these mechanisms make choice more real in the notice and choice framework. But contra to Professor Strahilevitz' last slide, and I know you weren't saying it this black and white, Lior, I don't think that that gets us out of the round robin over notice and choice as a good or bad or useful regime, as much as we might want to render it irrelevant and have deeper answers. It does go far, and indeed, as has been discussed today, that is a large part of what California does. It looks to make notice meaningful, backed up by rights, like rights to know what a business is collecting about you, rights to access that, and to create real choice. So actual implementable choice, as we've been talking about today, and also choice that is, again, backed up by actual legal rights to delete, correct, limit, and opt out of certain uses of your information. Related to that is the attempt to make that choice not just real, but exercisable. So we've talked today a little bit about the do not sell or share my personal information button, which is meant to be very easy for the consumer to click the button and not have to do much more in order to tell that website not to sell or share the personal information according to the definitions under the CCPA. The global privacy control and the opt-out preference signal, which we refer to as OOPS. So I realize we now have OOPS, drop, and today we're talking about boo, is intended to make that even more implementable, as is the delete request and opt-out platform, which I hope we can talk about more in the comments, because I think the design is interesting and important, and Lindsey picked up on some things about it that would be good to talk about. So that is all in line with Professor Strahilevitz' observation on the last slide, that at least some of the issue with notice and choice, which doesn't feel real to consumers and often doesn't feel real in a lot of scenarios, is the lack of implementability, either the lack of actual notice, the lack of actual choice, the lack of being able to make those decisions for yourselves and then and protect your own autonomous interests. But the reason why that is not enough of the story, and why looking at the sort of mechanisms by which blanket opt-outs either are implemented or not implemented, or used or not used, which was, I think, Professor Strahilevitz' ultimate sort of decision maker for success, is that that's only the beginning of the story. How did we end up with the rights that we ended up with? How did we end up with the CCPA and other laws in the first place? We ended up with it with 2 citizen initiatives. So if you think that consumers don't understand the details of things, often they do not. There are lots of studies that show that they do not. They often think they have more privacy rights than the law has actually given them. For example, for years, consumers thought that the words privacy policy at the bottom of a website meant that there were substantive privacy protections provided by the makers of the website. So we know that it's absolutely true that that people have imperfect information, but they overwhelmingly voted for 2 citizen initiatives. One was to add a fundamental right to privacy to the California Constitution in the 1970s, and the other was to pass the Consumer Privacy Rights Act, which amended and extended the California Consumer Privacy Act, and among other things, created the California Privacy Protection Agency. In that vote, regardless of sort of how granular the decision points were for people who voted yes or no, they were clearly making a choice towards having more privacy rights. And they were tying it, I think, to individual autonomy. The purpose of the California Privacy Rights Act is stated in a couple of different places, and the duties and responsibilities of the agency are as well, which is to protect the fundamental privacy rights of natural persons in California. That is completely substantive and fundamental, with attention to the effect on businesses. So there's a substantive balance that is weighted towards privacy already in the statute. And the law itself also builds that in. So, there's data minimization that's very strong. Dark patterns do not constitute consent. These protect autonomy principles. And why I end up needing to confront the substance and not just implementing the rights at a procedural level is because not every day, but frequently I hear sort of 2 things, or 2 different versions of attitudes or thoughts or concerns about the way the California law works. And I'm going to go with the complaint orientation of each of these, just so that to make it clear. One is, this is just notice and choice. All it is dressed up notice and choice. We know that notice and choice doesn't work to protect privacy. We know that it's whack-a-mole. It's all of the things that Professor Strahilevitz said. And this is fundamentally not privacy. I also hear this is a huge regulatory burden that doesn't really recognize or effectuate what we consider to be a privacy interest. It is a cost on business that is untenable, and it's going beyond the scope of what privacy law should cover. This is fundamentally not privacy. So we hear very sincerely from a variety of interests that in opposite ways, that the way the law works is fundamentally not privacy. That means that I have 2 jobs at any given time. One is implementation, and the other is balance. And the implementation part has its own sort of set of rules and structures, and that's great. But I want to talk about balance, because what I really hung up on in the paper, and I don't think Professor Strahilevitz actually said it in the talk, is when are blanket opt-outs appropriate? And he set out a test, which we did see, which were the transaction costs are in the right balance, contextual integrity is intact, there's comparative institutional competence, and the pricing of the terms works out. So that all makes a lot of sense, and that, looking at that and the examples in the case studies, show that it's really an analysis, at least on the page, that doesn't mean that's everything in your mind, analysis that is focused on implementation and very practical things. One, under what circumstances are blanket opt-outs implemented? And two, do they work? And as Lindsey pointed out, there's, not in so many words, but Professor Strahilevitz has a kind of a definition for when they work, which is that consumers use them, and they do what consumers think, and so forth. That is all very helpful, but it doesn't necessarily help me find that balance and and for that, I need to look for the underlying values and see how they are aligned with the appropriateness of this, like the literal definition of appropriateness. For example, the last criterion we talked about where businesses are willing to price is presented as whether consumers can make use of opt-outs, and that's important, whether they're willing to price. But there's also the question of whether businesses should accommodate blanket opt-outs and how we decide to do that. And on the flip side, there's the question of whether consumers should be able to exercise a blanket opt-out and how we decide. To do that, we have to disentangle the rule, or to not, like the mechanism, and the substantive rights and values. And so we go straight back in to having to understand what those underlying values are. I don't mean to say that you need to re-theorize privacy law again, Professor Strahilevitz. I just mean that I think it's going to be important to look in some more depth at the substantive rights that the procedural protections are intended to allow to be used, and to consider that from the perspective of substance. So I'll give a couple of examples, practical examples of where I think you need more granularity in your analysis. And one is that in categorizing the blanket opt-outs, you talk about whether it's about contact or whether it's about use. And I don't think that's granular enough, and here's why. Because use carries with it a lot of different things. It is both opting out of using personal information for cross-context behavioral advertising and deleting information that a business holds. In a practical sense, in a substantive sense, those things are quite different because they have different implications for both the business and for the consumer. And so we actually have different rules about them. We require much more authentication for deletion than we do for opt-out. Who cares if somebody opts you out of a bunch of spam emails? Maybe people care, and there's certainly context, but you don't need the same kind of authentication that you do in other contexts. And so I think that you want to consider, kick the tires of your sort of taxonomy and the way that you're using the blanket opt-out with attention to some of the underlying rights and how they may or may not protect and allow protect autonomy and allow consumers to exercise it, and also pay attention to exactly what that means for businesses. I think that will give you a stronger article. I want to say one word about the no solicitation example to illustrate this, which is that I agree with Lindsey that it's a very straightforward example, and it's helpful to get us started on the discussion, but in the end I worry that it obscures some of this complication, largely for some of the reasons that she discussed. And also because we know that the interests on each side are very simple. We've understood them for a long time, but there's not much to them. I have the right to let you into my house or not, period. And I can make that decision or not. So my substantive right is very clear. The solicitor would like to sell me something or give a donation, and I can decide if I want to let that happen or not. And so a blanket opt-out is pretty easy. As we've talked about a lot on the panel today, there can be a lot more nuance and complication when it comes to privacy, especially data privacy. But there's also more nuance and complication in other examples from real property law. I'm from the Ozarks, and the example that I thought of was a no hunting sign. Who in the audience knows what a no hunting sign means? Is anybody a hunter? Lindsay knows what a no hunting. What does a no hunting sign mean?
Well, I'm from South Dakota, but I'm not a hunter. I think it means you can't go onto the property to hunt.
But what if you don't have a no hunting sign?
Yeah, if you don't, if I'm in the field, I'm like driving by in my car with my gun, and I want to go into the field to hunt the pheasant, and it says no hunting. Doesn't that mean I can't go into the field and hunt the pheasant?
And what if there's no hunting sign?
Oh, interesting. I think then you can, but if the owner comes out and tells you to leave, you still have to leave.
This is not intuitive today, is it?
Yeah, oh, interesting.
Yes.
It
Tell
depends.
me.
There's some variation from state to state.
Yeah,
so
I figured you would know this.
Right.
Yes, and this is so. Let me say a little bit more about it, and I'm terrified of it because it is so complicated and so counterintuitive, at least to my modern mind. Even as I grew up in the Ozarks, where there is a lot of hunting, that I know I'll mess it up. But the idea is to test your examples through something more complicated like this, where the underlying rights are more contested. So without the no hunting sign in a number of states, a lot of states, and this was the traditional Anglo-American model, you could go on somebody's land and hunt. One reason why I think this is interesting is that for the no solicitation example, you're in my house, you're out of my house, I'm spending time with you, being, pushed to buy something, or, maybe sold something I want, you want to buy something. It isn't about extracting value from the house or the person other than that particular transaction that you understand. And that was sort of embedded, I think, in some of Lindsay's examples as well. The retailer has value when it collects your information, but it is an extraction of value from the consumer. I don't know if that's wrong or I don't know if that's right, but if somebody goes onto my land and hunts, I think of that as an extraction of value in the resources on my land, in the the land being damaged, et cetera, et cetera. But historically, that's actually not always the way that it was thought about. So in England, the thought was that only the nobility, it was so appropriate, to use your word, Lior, it was only appropriate for the nobility to hunt because the people who were not nobility needed to spend their time working, and this pleasant pastime wasn't available for them. And nobody really cared about the borders of the land in the same way unless it was being used for agriculture. Agriculture made it more valuable. And when this was imported to the United States, or when the United States started, as you might expect, the founders were like, this is horrible, this is nobility-based, everybody can go everywhere and hunt. And we still care if you are, quote, exploiting the land, which means engaging in agriculture, not having animals on the land, not protecting it as an ecosystem, not, avoiding stray bullets. These kinds of things are more important. So the defaults are you hunt, and you have to put up a notice not to hunt. Whereas, as Lindsay said, the house, the default is that the door is shut, and you make the decision, and and thus the blanket opt-out is simply supporting that. I think when you think through, Lior, some of the examples, along with some of Lindsay's examples, and then I always run it through my statute in the California Constitution, it may complicate your analysis a little bit and help you get to a sort of a taxonomy of blanket opt-outs and a yes or no or why or when that's a little bit fuller. So
Thank you, Jennifer. I'm going to add a lightning round of comments, and then we're going to give Lior a chance to respond. So first of all, thank you so much for your wonderful paper. It was fascinating. Thank you, too, for your kind words about Cal and the opportunity it creates. And so Sebastian Zimek, who you mentioned a couple of times, or it's been mentioned a couple of times, came here as an LLM student and then went on to be a Columbia PhD in computer science. He's a professor at Wellesley and now visiting professor at Columbia University. So go Cal. Second, really interesting part of the paper about the EU model versus the US model. Really loved your comparative analysis. One thing that occurred to me is because the cookie control mechanisms on some EU websites are so insanely granular, they create a kind of perverse incentive, I think, for the user, so that it turns into a kind of notice and choice where all you want to do is agree to accept all, because the choices that it offers you are just so insanely complex. And basically, you just want to read whatever the newspaper says and not spend a lot of time pondering all the different choices. To the extent that the choices of the viewer or the user are going to be similar across different websites, as you argue is the case sometimes, this creates a perverse incentive in the EU to have a lot less privacy. And then finally, I really liked your contact versus use table in the wonderful chart that you have on page 46. Very interesting reflection right now by Jennifer, how use can mean different things. At a simpler level, I just love the basic distinction, because it's my belief has always been that in the U.S. there's a large focus on use of information, less so on collection and contact, in part because our powerful First Amendment, part because I think of an intuitive belief that information flow per se is a good thing and positive. Whereas in the U.S., in the EU rather, the starting point for privacy has always been it's forbidden unless there's a reason or law, for example, that you can point to that would allow you to use the information. So the starting points are quite different. So for me, it is a fascinating nuance and window into U.S. privacy law that we actually have a version, although admittedly in niches, where you can't collect, you can't contact from the starting point. And so interesting enough, in your chart, it's 6 of the examples are no contact and 4 are use. So really kind of insight into an aspect of U.S. privacy law that I had not noticed before. So that's my lightning round, and let's go to Lior.
There's so many great points and such generous comments from the three of you, and especially constructive criticism, as we regard that as the most generous comment. So thank you for all that. I have a lot that I want to say, and I'll say a lot of it in the final draft of the paper. So I'm just going to maybe make like 3 sort of broader points. I think the biggest reaction I have to Lindsey is I think you're absolutely right that consumers don't understand privacy. They're often very much in the dark. But what I want to say is it's equally true that lawyers who do privacy and scholars who write about privacy also don't understand consumers. And by that I mean the following: we often assume that they're just like us, and that they have really thought about these issues, and they really care about these issues, and they've got a lot of nuance. And I do a lot of empirical work on ordinary consumers, where we survey them, we run experiments. And what I will say is, if I can broadly characterize their attitude, they're just like, why are you complicating things unnecessarily? Like, just, I either want this or I don't want this. I want to buy this product, or I want to protect my privacy, or whatever. And I think the mistake that we often make about consumers is to assume that they've just got they've really thought about this stuff, and I just think for the most part they haven't, and the kinds of distinctions that we tend to draw and that law often tends to draw just don't resonate with them at all. I think the other thing I wanted to say that I think is just important to articulate at the outset is, I didn't talk about it in the presentation, but there is a part of the paper about blanket opt-ins, and sometimes privacy regulations can err in the wrong direction. We can be overprotective or underprotective with privacy. So I do give the example of, I live in Illinois, and I'm constantly encountering biometric information privacy consent requests, which you all in California aren't, because you don't really have a strong biometric privacy law in California. And my sense there too is a lot of people sort of I love your example about, I just always want to tip this amount, or I always want to opt into the loyalty programs. Those seem great to me. I'd like to facilitate that too. But whether it's EU law or Illinois BIPA consent notices, I think there's some people who are yeah, I'm fine with biometrics. And just like I'd like to facilitate autonomy for the choice for people who've just made a gestalt, I really do care about my privacy, I'm comfortable, maybe in a way some privacy advocates wouldn't be, with giving people who say, yeah, biometrics, it's fine with me. I want to say, are you sure? Yeah, okay, great. Then we can do whatever we want with your biometrics. But I really appreciate the wisdom of your comments. I think there's a lot there that I'll take forward. Jennifer, absolutely the same, and thank you so much for your great work. Here's kind of the one sort of meta reaction I had when we were thinking about notice and choice, which is, you and I have both worked hard on the dark patterns problem, which is manipulative online interfaces, and I was really honored to get to help CPPA when it was thinking about dark pattern regulations and to testify about dark pattern regulations. And I've increasingly come to the conclusion that notice and choice is basically just an obstruction dark pattern. Obstruction dark pattern is where we place obstacles in the path of a consumer in order to exhaust them into doing the thing that the interface designer wants them to do. And I do worry, when Lindsey says, look, the people who really care about privacy, sometimes they should have to prove it. Sometimes they should have to go to 20 different websites and fill out these web forms. And I'm a social scientist who collects a lot of this data, and I just know none of them will, even though some of them really do care about privacy. And I worry that this whole, we really want to make sure we're giving you exactly the level of privacy that you want, given sort of that we're in a capitalist society, and that businesses need to make money, and they're going to sometimes do that with your data. I really worry that we're favoring let's make sure we're giving you exactly what you want and tailoring this suit perfectly, when people are kind of coming into the tailor's office and just being give me a blue suit, because the costs of these tailoring are, you're not going to be able to get out of the tailor's office in 30 seconds. You're going to take 10 minutes there, and by the end of it, you're going to forget why you were there. You're not going to want a suit. You're going to decide you want to wear something else entirely. So that's So I'm increasingly sympathetic to the idea that there are some people who have really granular, well thought out privacy preferences, and that's true of the four of us, but it's not true of most people. And for most people, we'll lose a little bit of nuance and in some sense not be as respectful of their autonomy, but in a broader sense being much more respectful of their autonomy if they've just got an overarching, I want a blue suit, I don't care how long the arms are so much, if we're willing to respect that kind of autonomy as well, even though that seems really incompatible with important aspects of U.S. privacy law and hugely incompatible with basically all of European with all of European privacy law. But I want to think more about all the different challenges that you made. And Paul, I would almost say the example you gave at the end of the cookies is part of what makes me think, and how out of control it's gotten in Europe is part of what is sort of driving me to that view of notice and choice as a kind of dark pattern. At the end of the day, it's well-meaning, right? It's well-intentioned, oftentimes, and it comes from a good place. But I think it's sometimes attempting to impose on the typical consumer a kind of superstructure that they just don't buy into and that they just agree. And so the results that we get when we ask them to consent or not consent to things are just going to be kind of garbage in, garbage out, versus something that's cruder, but at the end of the day, it might be closer to where consumers are.
Thank you so much. So we will conclude now. We'll have plenty of time for questions and conversation at a reception afterwards, but we have some concluding remarks.
Yes, thank you so much for joining us for the 18th Annual BCLT Privacy Lecture. We would like to thank all of you for attending, as well as our speakers, Professor Strahilevitz, Professor Schwartz, Lindsey Tonsager, and Professor Urban. Again, we would like to thank Professor Paul Schwartz for moderating, and the Berkeley Center for Law and Technology staff for coordinating this lecture. We now encourage everyone to stay for the reception. Please mingle and enjoy the light refreshments provided, and join me in giving a final round of applause to our speakers and organizers.
Thanks.
And allow me to thank you to the audience for being here. Thank you, Annie and Gabrielle of PrivLab, for your wonderful introductions and for all that you contributed to this event. And of course, thank you to the BCLT, the wonderful staff who make all the trains run on time. So thank you.